The Colorado Rental Agreement. In this video, we will tell you about the most noteworthy aspects of rental agreements in the state of Colorado. What is a rental agreement? A rental agreement or a lease is a document that outlines the arrangement between two parties regarding a property rental. The one who's paying rent is called a tenant, while the owner of the property, who lets the other party use it under certain conditions, is called a landlord. The parties may also be called a lessor and lessee. Typically, a rental agreement lasts for 6 or 12 months, with rent being paid every month or every week. There is one federal disclosure that works for all lease agreements in the United States. This is called the lead disclosure, and it requires the landlord to tell the tenant about all known lead paint hazards. They should also provide the state-approved version of the pamphlet, Protect Your Family from Lead in Your Home. However, this requirement applies to not all types of residential dwellings. Required disclosures. Apart from the above-mentioned disclosure, there is no other mandatory information the landlord should disclose in a rental agreement. However, adding more disclosures helps reduce future conflicts and legal liability. Security deposits. In the state of Colorado, there is no statutory maximum for the security deposit. The deposit shall be returned by the landlord within 1 month after the termination of the tenancy, unless previously agreed to other deadline, but never more than 60 days. If any damage is caused to the premises by the tenant, the landlord can use the deposit to pay unpaid rent and to repair any property damages. Then, the itemized list of withholdings is needed. If the landlord fails to mail the security deposit or an itemized list within the set period, the tenant can receive up to triple the amount of that portion of the security deposit wrongfully withheld from the tenant, together with reasonable attorney fees and court costs. Landlord access. In the state of Colorado, there is no required notice period for the landlord before entering the rented premises to inspect them, make necessary repairs, etc. However, a 24-hour notice is always recommended. Termination of agreement. For termination of a year-to-year lease, a 91-day written notice is required. It can be written by either party. For termination of a month-to-month lease, at least a 28-day written notice is required if a lease is 6 months or longer. In case of a week-to-week lease, at least a 3-day written notice is required by either of the parties. Notice periods for non-payment and non-compliance. If the tenant fails to pay the rent or violates other terms of the lease, the landlord should send at least a 3-day written notice to pay or remedy the violation or quit.